Thank you everyone for tuning in. This is the Paws and Policy webinar, Keeping Pets and People Safe in the Multifamily Community. So we're really excited with the interest that we got with this one. And I do want to take a moment to thank the Greater Cincinnati and Northern Kentucky Apartment Association, as always, for sponsoring this. I know a lot of you guys are a part of that apartment association, and we love having you all here. First and foremost, we'll do a quick agenda. I'll jump through some introductions for everyone that is a panel here on this webinar. We'll do a quick overview of what to kind of expect and some stats and data that we've collected surrounding pets in the multifamily community. Then we'll hand it over to Amanda to kind of speak to some of the liability risks that you can expect to see as a property owner, and then some implementation policies that'll work to kind of mitigate some of that liability. And then at the very end, we'll have a Q&A where we'll cover some of the questions that we'll see in the Q&A. But that being said, if you have a question that jumps up at any time, don't hesitate to throw it into the chat and we can address it as we kind of come through it with certain topics. So we'd love for this to be a little bit more interactive. Again, if you have any questions or thoughts, go ahead and share them in the chat and we'll get to them when we can. Let's go ahead and start with some introductions. I'll start by introducing Victoria. She is tuning in with pet screening. She brings decades of multifamily expertise and a passion for bridging strategy and compassion. She's a leading national operations expert who speaks to furry, fair housing, and pet policy. And she'll be sharing some practical insights on assistance animals, breed restrictions, and turning pet roles into pet culture. So that'll be really great. Victoria, we're really happy to have you here. Thank you for joining us.
Hi, Jen. Hi, everybody. Thank you for having me. I look forward to it. I appreciate you inviting me.
Okay, and also another panelist we have is Amanda Podlucky. She is tuning in from Cobb and Gonzalez. She's a partner with Cobb and Gonzalez and a leader of the firm's general liability practice group. Amanda specializes in property management and liability law. She's going to be breaking down what property managers must know about risk mitigation, enforcement, and fair housing compliance related to pet policies. I know you guys are all so curious about that. There are so many questions that surround having pets in multifamily communities and some of the risks that come along with that. And then just a quick introduction of myself. My name is Jen Free. I am with Cloudastructure. We do AI surveillance and remote guarding services for the multifamily realm. I started off on the operations side, so I've been a property manager. I've been in your shoes. And oh my goodness, dealing with people not cleaning up after their pets was one of my biggest nightmares, because at that point it was always my word against theirs. And that's one of the reasons why I'm so passionate about the solution Cloudastructure that we offer, because it's verified video. It's very easy to share to tenants. And I'll show you a little bit more about that once we get a little bit further along. But thank you again, Amanda and Victoria, for joining us. And if you can see at the very bottom of the screen, we have a picture of each of our pets. Victoria, which pet is this? I know you threw some of those names in the chat.
That's Princess Natiri, named after the lead character on Avatar.
Okay. And Amanda, you've got a cute Pomeranian here.
I do. That's my little Jasper. He is 12 years old now, but you would never know. He still acts like a little puppy and he's full of fluff.
Adorable. And I have my little cat. Her name is Savi. This is when she was a kitten. She's no longer a kitten anymore. She's 5, but this is my absolute favorite picture of her. And Savi is short for Sauvignon Blanc. For those white wine lovers. All right, great. So we'll go ahead and jump into it here. So a quick overview of Cloudastructure and what we offer. So as I mentioned, we do AI surveillance and remote guarding solutions, specifically in the multifamily realm is our real bread and butter. And so we really offer that proactive deterrence of unwanted activity. The idea of being able to step in when that unwanted activity is happening right then and there to deter it from progressing any further. And we do that by utilizing live agents in a remote center, utilizing our technologies, analytics such as facial recognition, license plate recognition, line crossing alerts, object detection. And then we place a speaker where our agent can do a live talk down and deter the transient, the suspicious activity, or the suspect from progressing that activity any further. And we're able to save properties a lot of time and money when it comes to deterring property damage, deterring lease violations, crime, and also by mitigating vacancy costs by bringing crime down on property. So a really quick rundown of Cloudastructure and what we offer. I'll speak a little bit more to it a little bit later. But that being said, Victoria, I'm going to hand it off to you if you give us a quick background of pet screening.
Thank you, Jen. I appreciate it. Hi, everybody. So pet puns are going to run amok when I'm on your call. I'll offer that as a disclaimer. So we're the big dogs in the pet screening world. This is not a DNA type service. This is literally like renter screening, but for the pets. There's probably 50 million some odd pets in rental housing in the country. And so we are your data, your time, your risk, and revenue management partners. We're going to get you all of that data for each household, whether they're a no pet household, a household with pets, or a household with assistance animals. We're going to get that data. We're going to save you that time. It's going to be better data than you've ever had before. We're going to score all of your pets for you on our FIDO score. You're going to tell us what's a no for you. That's a 0 on our FIDO scale, or we're going to give it a 1 to 5 paw on our FIDO scale. We're going to let you see the risks so you can determine how much of that risk you want to take on. And lastly, we're going to process all of your assistance animal accommodation requests for you, so you don't have to engage in that rough process in the future with that friction with folks you just rented to or folks you're wanting to renew the leases of, right? So we become your partner in all those regards. We do not charge you for our services, and we do not ask you to sign a contract. And we are serving 1 out of every 7 doors in the country right now. And we have returned probably about $400 million in reclaimed pet revenue by this time. So thank you for the opportunity to introduce pet screening to your attendees today.
That is huge, Victoria, and I'm sure everyone on this call loves to hear that about that generated revenue. Thank you again, Victoria. From there, I'm going to hand it over to you, Amanda, if you give us a little background of Cobb and Gonzalez.
Thanks, Jen and Victoria. It's nice to be here with you today as well. I'm happy to be able to talk about this. So just as a little bit of background, Cobb Gonzalez is a Florida-based firm. We cover the entire state of Florida. We have offices in North and Central Florida. We're essentially a comprehensive legal services firm for businesses, anywhere from construction, real estate, all the way to general liability, pretty much covering all those different topics. I specifically handle general liability matters with a large focus in multifamily housing claims, a lot of, your standard trip and fall, slip and fall type claims, but we have our very large share of dog bites as well, which is why this is such an important topic to discuss here today.
All right, so let's jump into the meat of it. Let's get some data and statistics out there so we can kind of realize the brunt of it all and how important this topic has been as of late. So top renter groups as of past have been the Gen Z and the Millennials, and they obviously want pets. They say pets have become the new kids. A lot of people are adopting pets in place of having kids as a family. And so together between Gen Z and Millennials, they own 49% of the pets in the country, which is huge. And 76% of Millennials own pets. Those are huge statistics, huge numbers. So you can see that it can become more of an issue the more people are adopting pets, bringing pets into the multifamily community. And so apartments.com says that pet policies are number 2 when determining where someone wants to live, only number 2 after pricing. And Victoria, do you have anything that you kind of want to add to that? I know these are statistics that you were able to share with us.
Just that these numbers are going to go higher. Your Gen Zs, our Gen Z and Millennials are our top renter groups. They make up 72% of our renters today. And your Gen Z's lowest age right now is 13 or 14. So they're not all adults. And they, to combine with the Millennials, already own almost half the pets in the country. And if Millennials themselves have 76% have pets, you can imagine what's going to happen as the Gen Zers age. So this number is only going to rise. I think that's the most important point here.
Great to have you guys all here because you were going to be sharing some important information as pets become more prominent in the multifamily realm. So that being said, we'll take a turn into talking about some of the challenges with bringing pets into the multifamily world. So noise, damage, complaints. Victoria, I'll let you touch on this one.
So we recently released here at Pet Screening the State of Pets in Rental Housing report, and that revealed from those respondents 28% on average of the units incur damage, and that pricing is at about $592 an average cost. So I think it's great to see what the likelihood of impact and damage to the units might be and the cost so you can back into the numbers that you need, right? There's opportunity when you welcome pets into your community, but there's also risk. And so how do you position your policies to address that so you can reclaim that while still maximizing the creation of community and satisfying your renters, right? So knowing those numbers helps you to back into them great. We also had a report a few years ago that talked about the top concerns that renters actually had. And that was our 2020 study. And I don't think that the answers will have changed. The top issues for renters, what they did not like about pets in housing, were basically barkers and, I'll say it, perpetrators who do not clean up after themselves. And so these were their top two concerns. And so that can lead to maintenance costs, time that maintenance is spending, and maintenance time is incredibly precious. So these are their top complaints. And it can lead to additional maintenance, and it can impact your landscaping as well. So these are your issues and your challenges. And so backing into the right policies to address these and knowing what's important to your renters, I think, is super key, Jen.
All right. So I think this is one of the most important topics that we're going to be covering today. And I think one of the reasons a lot of you have tuned in to learn about the liability of being a property owner and managing residents that do have pets. So Amanda, this is your expertise. Let's hear what you say. And I'm curious if you could tell us kind of a little bit about what you've seen in court.
Sure, of course. We see a lot of dog bite claims in multifamily housing property situations. I think when people think of multifamily housing properties and general liability, they're obviously thinking of your slip and fall or your trip and fall, things like that. But I think people underestimate how many dog bite claims there can be in a community that is very pet forward or pet focused, because these things tend to happen. And certainly that's unfortunate for the property, but it's so important that we really know how to understand know and understand how to navigate these claims and these risks. So the first thing that I'll kind of let everyone know is most states, obviously I'm in Florida, but most states find the dog owner strictly liable. And there's different levels of, whether the dog has a history of violence or viciousness or not, but a lot of states do hold the dog owner, the tenant, strictly liable. So a lot of times when we see these claims filed, we're going to see the property manager, but also the dog owner named as well. And typically that's a point of contention, and we're obviously trying to shift that risk over to the tenant as the dog owner. And a lot of times, the lease agreements are probably going to have language contained in the agreement that provides for the dog owner to maybe defend and indemnify or cover costs and things like that. So the property obviously wants to shift the risk to the dog owner. And typically the claimant or the plaintiff wants the property involved. They want the property to be on the hook because the property is the one with the deeper pockets, right? Even if you have a renter's policy, it's probably not going to cover a lot of damages. And sometimes these plaintiffs are looking for a lot of money, a big recovery, even if it's a small injury. So the plaintiffs, the people that are bit, the injured parties, they're going to want to put the focus on the property. The property is going to want to put the focus on the dog owner. And so we have this constant, push and pull between the parties and the dynamics. So one thing that we really look at when we look at these claims is that lease language that I mentioned. We want to make sure the lease language is clear that the dog owner should be responsible in the event of injury or damage. Now, a lot of lease agreements do not contain the language that require the dog owner to cover those costs or to be responsible or to indemnify and defend the property if the property is also negligent. So I know this is very nuanced and a little complex, but essentially if these claims are filed, you have a strict liability claim against the owner, meaning the dog bit me, you're responsible. And then against the property, who's not the dog owner, that's just going to be your standard negligence count. So they still have to prove these things. And again, the property, if they want to shift the risk to the owner, they're going to want the owner to take care of that, take care of the cost, take care of the expenses. And that's where it's important that if you can add into the lease that that by means of owning the dog, they should be responsible, even in the event of the property's negligence. That would be very helpful. And yes, a lot of times your renters are not going to have money or assets to pay the legal fees or the lawsuits. But a lot of the times where these properties require the renter's insurance, their insurance carriers do have those means. And that's where the properties can be successful in shifting the risk to the dog owner, is if we have that language that is very cut and dry in terms of the dog owner's insurance, renter's insurance, picking up the tab. So having documentation in place up front, and I know we're going to get into that a little bit probably later on, but making sure we have that documentation in place about the dogs on the property, who lives where, what dog is on the application, making sure the pets that live in the apartment are on the application, making sure that there were background checks done, that pet deposits were paid, that records are on file. If you need vaccine records or whatever the case is, you need to make sure that these residence files are very well documented with the pet information that live on the property. That could not be more important, because if one of these dog bite claims happen, it's very difficult after the fact to go finding that information or digging for that information. You want to make sure you have a signed lease, the pet application, the pet addendum, any other addendum that might apply to pets. You want to make sure that you have that signed lease there. You want to have the dog's information readily available for you, and having that stuff in order is so very important. And then just quickly to shift gears to after that incident or that bite happens, documentation of what happened is even more important. You want to make sure that immediately after something is reported, that you have information about the pet owner, the pet, what happened, get statements. If there is surveillance footage of the community, if this happened in a common area, such as a dog park or on the pathways. Obviously, Jen, this is where Cloudastructure certainly comes in to play. You want to make sure that you're pulling that footage and preserving it right away, because we want to know exactly what happened. And a lot of times, especially for the negligence claims against the property, provocation is oftentimes a defense, or very helpful in defending. So if you have someone that says, this dog bit me, I was doing absolutely nothing wrong, and meanwhile it's in a dog park where there's an ongoing kind of scuffle and that wasn't the case, we want to know that, because we need to be able to determine the defenses right out of the gate. I know that was a lot of information, but it's kind of the nuts and bolts of the dog claim and what you really need to look at from start to finish when we have these things pop up.
I do have a question. So, as a property owner, can they require pet owning residents to carry liability insurance? And is that enforceable in court?
Yes, I mean, I think a lot of properties that I work with require renter's insurance regardless of the pet. So that is very much doable. I think it's important that they do if they have a pet. I think it's important that renters do have renter policies, but it's important that the renters are obviously upfront with their carrier, and that's something that is hard to enforce. Honestly, how do you make sure that the resident, when they're applying for the insurance, discloses the dog? Or if they get the insurance policy and then get the dog subsequently, are they letting that carrier know, I got a dog, what kind of dog it is? So sometimes the carrier might have an issue if the breed isn't disclosed, or if it's a particular type of breed, they might have breed exclusions. So you want to make sure that you do have, not only have your renters get those renters policies, but you have them on file so you know exactly what is included in them. And if for some reason you see a specific exclusion, or you see that they didn't disclose the dog, then obviously, if you know they have a pet, then you can address that with them and make sure that it's taken care of. And that all goes back to that documentation.
And you kind of brought up ESAs and dog breeds and everything like that. So I know there's a ton of questions that are going to be coming up surrounding emotional support animals. There's a lot of different ways to label them, and there's some right ways and some wrong ways. And so with that, I want to hand it off to you, Victoria, to give us a little bit knowledge surrounding how to properly classify specific animals.
Thank you. I appreciate that, Jen. And before we close out the comments on that last slide, I do want to say this is such a problem in our country. Dog bites rose in 2024 almost 19%. We now have a dog bite Prevention Week in the country. This is such a sincere problem. 4.7 million people a year get bitten, and 800,000 of those need medical attention. So I salute everything Amanda just shared and just want to put an exclamation point behind it all. So thank you for that, Amanda. Now, we have processed probably 1.5 million reasonable accommodation requests here at Pet Screening. And this was always something I did personally for my portfolios that I managed when I was an operator. And so it became a passion point for me, making sure we were properly respecting the rights of the disabled, because that's what we're talking about here. So I'll kick it off there. So with the fair housing legislation, and then comes the joint DOJ HUD letter, and then now comes the most recent HUD notice. We've got 3 pieces of this puzzle to contemplate every time we're trying to address assistance animals in housing and reasonable accommodation requests. So let's talk about the disabled individual and the reasonable accommodation request, and then Amanda and I will probably kick this back and forth a little bit. So we'll start off with the disabled individual. That's a person with a physical or mental impairment that substantially limits one or more major life activities. Could be someone who's on the record or regarded as being disabled, and it may be even that you have personally witnessed that they are disabled, and so you have that knowledge right off. But again, the essence of the definition is someone with a physical or mental impairment that substantially limits one or more major life functions. And for the purposes of our conversation today, they're requesting a reasonable accommodation, which is simply put a change, exception, or adjustment to your rules or your policies. And so in this instance, in this arena, generally what they're asking for is for you to set aside your pet policies, because an assistance animal is not a pet. And so that entails setting aside your pet pricing and your potentially your weight limits, your breed restrictions, anything you have around a pet. And ideally, when I'm doing webinars on this, which my webinar on this is called You Bet Your Assets for a reason, when I'm doing that, I tell folks, please consider the assistance animals as you kind of run through all the traps and questions as you're operating your communities. Maybe change the word assistance animal to walker or wheelchair. Can the resident in 2B take their assistance animal into the fitness center? And Amanda's going to get into this, but I'll say substitute, can the resident in 2B take their walker into the fitness center, right? And so I think that might be a great place for us to start off. Now there's service animals and support animals, and now I'm going to kick it over to Amanda.
So again, going back, and I'm going to keep saying documentation as many times as I can, because that is the most important thing when it comes to dealing with claims and dealing with risk issues, and making sure if you do have a resident on the property who has an ESA, a lot of properties will have an additional ESA addendum or agreement in addition to your general pet addendum. So it's important that that is documented. If somebody comes in with an ESA, and obviously as Victoria mentioned, some of the disabilities or accommodations might be apparent. Some of them might not be. It's important that you get the documentation if the animal is in fact an ESA. You want to make sure that it's documented, and if you do have an addendum, that is completed and signed, and that they're both in the residence file. Now, typically, most properties or states or whatever the case is, if you're going to have a breed restriction for general pets, that would not apply to an ESA. And I know, we have all these animals on the screen here, from the parakeet to the, I don't even know what some of these little creatures are, the iguana maybe. So you have all these animals, and obviously there's a number of animals that can actually be ESAs. But really, when we're talking about risk, we're really talking about dog bites. I mean, sure, could you walk your iguana on a leash and he could bite someone? Probably, but for the most part, we're talking about dog bites here. So if you have your dogs and they're on the property and they're an ESA, and it is an otherwise restricted breed or mixed breed, and they're an ESA, and you're going to allow them on the property due to the required fair housing laws, then again, that documentation needs to be in the file so that you know what type of breed it is, and you know that it is an ESA, so that if something happens, you're not going to have a resident saying, well, there's this pit bull on the property and it shouldn't have been there, et cetera, et cetera. If it's allowed to be there because it's in an ESA, again, that documentation is very important. You cannot typically in most places restrict a specific breed based only on the breed from common areas. So you cannot say, well, you can have your pit bull in the apartment, but you can't take it to the gym, or it can't be at the dog park because it's merely a restricted breed if you do have restricted breeds. But that said, it's not a blanket exception. If that dog does show some sort of propensity of violence or viciousness, and you have good cause or grounds for an exclusion from a common area, then that is a different situation. So it's important when you have these ESAs, if they do straddle the line of maybe an otherwise restricted breed or animal that couldn't be on the property, it's important again that you're very aware of the residents that have these animals and the animals' behavior. Obviously, you're not checking on the animals, you're not going into their apartments to check on the disposition of the animals, but if they're walking the dog around the property, and you see the interaction of the dog, you're going to notice if this dog seems overly aggressive and you're scratching your head about its qualification as an ESA, if it walks like a duck and talks like a duck. So you have to make sure that you're really knowledgeable about these animals that are on your property so that you can be aware of any issues that might come up in the event that you do need to make specific exceptions to a common area allowance.
And on that, Amanda, can I also ask what's the risk of denying a resident's request for a reasonable accommodation involving an animal?
So that's certainly tricky, and that's certainly there are obviously under various fair housing laws and remedies and things like that. A lot of the laws sometimes there's statutory fees and costs in addition to just general compliance issues with local and state government, federal government laws. So you want to make sure that you're compliant. But then again, I'm going to say that magic word, documentation. If you're going to restrict someone or prevent somebody from having the animal, if the certification just doesn't look right, you have questions about it, it's okay to push for additional information to make sure that it's legitimate and that it's documented. As long as everything's documented and everything works out to where you have the proper forms, the proper certifications, the proper records, then it should be fine. And if those things don't add up, then I think you're okay to keep asking for information until it does add up. Because if something happens on the property and you allowed that dog on there where it wasn't an ESA, there's also going to be problems. So it's a very fine line. It's a very delicate balance, but the resident should be able to provide that information very easily to the property.
And Jen, if I can,
Okay, yeah.
I'll jump in here for you. I will say that there's two pathways in this. So when Amanda's talking about documentation, she's really honed in on something important. For your service animals, though, I want to jump in and say we can't require documentation of service animals according to the most recent HUD notice. So for service animals, we're asking two questions. Is the animal necessary for a person with a disability? What work or task has the animal been trained to perform? On the support animal side, that's where we're requiring documentation, and there's 4 things you have a right to see in there. And so Amanda's right, you can keep pushing until those 4 things are making sense. For instance, if they send you that doggy certificate that this is a support animal and it's been certified by the Emotional Support Animals of America, HUD has said that document in particular, that one for the animal that tells you nothing about the person's non-visible disability or their disability-related need, is, quote, not worth what the public's paying for those. So when you're processing your reasonable accommodation requests, there's one process for service, one process for support. Documentation, yes, on the support side, no on the service side. And when we're processing those for our clients here at Pet Screening, oftentimes on the support animal side, we will authenticate with each one for a support animal. We will authenticate the document with the provider of the document. And there are occasions where we will find fraud. When we contact the provider of the document to authenticate, that provider produced that document for that requester with that date on it, and those things are not adding up, that document has been fraudulently created or fraudulently edited, right? And so the outcomes can be really interesting. But again, dating and timestamping everything as we do is super important, and having all that documentation and making sure you're approaching a service animal the way it's supposed to be approached and a support animal the way it's supposed to be approached differently on those different pathways is super important.
What would you suggest would be the best way to handle a resident who claims that their pet is an emotional support animal, but is not?
Well, I guess Amanda and I are probably going to both say we'd have to know how you got to, but it's not. So for me, the process that HUD outlines in their most recent HUD notice is the process that we go through for our clients, the process I would recommend any of your folks use here today. With that, they're answering the same 2 questions they would answer for a service animal. Is the animal necessary for a person with a disability? And, what is the nexus or the relationship between the request and the disability? Not everyone who's disabled has a need for an assistance animal. There has to be a nexus. So for instance, a person who has extreme anxiety leaving their home might have an assistance animal recommended or prescribed, if you will, by a healthcare provider. Again, these letters don't always have to come from a healthcare provider, though. But in this instance, this person gets a letter from a healthcare provider so that they can have that animal with them when they leave their home to help ameliorate the symptoms associated with their anxiety. It makes them more comfortable and confident to leave their home maybe with that animal, right? So there's different connectivity for different disabilities, and that connectivity between the disability and the need is that nexus. And so I guess I'd have to know how you got to the point that it's not a support animal. And sometimes I'll throw this cautionary in there. Sometimes we see folks with animals out on property and the animals maybe not behaving so great. And we're like, how is that an assistance animal? An assistance
Right.
animal means when they're in their home, this is fair housing, when they're in their home or elsewhere, that animal ameliorates one or more of the symptoms associated with their disability. On the support animal side, that doesn't mean the animal's been trained in any way, shape, or form, and we're not allowed to require training requirements or require training certificates. So we don't know that it has the best training. We know that it's been suggested, prescribed, recommended for them because there's a connection between it and their disability, and it's going to ameliorate one or more of the symptoms associated with that. Could it go down a bad road? Sure, it might be badly behaved, but I'd have to get back to how do we know it's actually not an assistance animal? Maybe we're thinking more along the lines of it might be an assistance animal, but it's really behaving badly. And then that's a great conversation to have.
And Amanda, one for you. Are there any legal issues with charging pet rent or deposits for assistance animals specifically?
Typically, most pets are going to be subject to a pet deposit. I think there's a lot of properties that I've seen that do waive those for assistance animals. And I think that a lot of times that's done on a property by property basis. And a lot of properties want to do that for their residents with, disabilities or special accommodations. So I think that's kind of a little bit subjective of a question. I think it's a difficult one to address across the board. But I do see that a lot of times being waived for ESAs and service animals.
Well, let's go ahead and transition over to some strategies that you can utilize to keep your community safe with pets in the multifamily realm. So, Victoria, I'll hand it back to you to talk about some of those strategies.
Thank you. I appreciate it. Can we share that next slide? So here's a couple of suggestions that we would make here at Pet Screening for you. We have a policy about how you want to handle confirmed biters and get to that by being sure that you're asking that question. Because as Amanda will tell you, this always comes down to the attorneys asking when something has gone wrong, what did you know, what should you have known, and what did you do about it? So you want to ask, has the pet ever bitten a person? You also want to ask this for the assistance animal piece because HUD has said one reasonable accommodation might not be an accommodation that presents a threat or hazard in your community, right? And so you always want to ask of pets or assistance animals, has your pet or assistance animal ever bitten someone? And you want to have an SOP for what you'll do if they say yes. Now, most of the folks on the call will say, well, what happens if they lie? That's, it comes down to what did you know, what should you have known? If you're asking the questions, you're doing your part, right? We can't make everybody tell the truth, but you are doing your part and you can prove what you knew or did not know. So there's your risk mitigation there. So have a question about biting and then an SOP for how you address that. Ensure every applicant and renewing renter stipulates that they understand and agree with your policies, and have your no pet household stipulate they understand in particular that there's no pet sitting or pet visitation or fostering for any length of time inside or outside their rental unit without advance written authorization. That language goes a little bit farther than most any lease I've ever seen, and I highly recommend that language be utilized. Consider having a standard process for approving visiting pets, right? And running them through the same process so that you can always have a handle on operating a healthier, better managed pet environment for your renters. This prevents unknown pets and animals who've not been through the property management company's standard process from being on property, or potentially reduces the chance of an operator being held liable for an unknown pet or animal that engages in harmful behavior while on property. I'd also suggest responding promptly to situations as they arise that appear to pose a threat or hazard and have a standard SOP for doing so. Amanda mentioned earlier, being familiar with the pets and assistance animals on property. And if you've previously approved an assistance animal and you're out on property, you're conducting a bark park yappy hour party, and you see somebody coming in with a pet or animal that they can barely contain that is very aggressive, have a response, an SOP to respond to that and do so promptly. Because again, it all comes down to what did you know, what should you've known and what did you do about it. Again, I would suggest requiring all dogs to be on a leash when they're on or near the property, regardless if your local ordinance speaks to leashing or control. Some local ordinances speak about control, and so some people will say, but the local ordinance says control, so I don't have to have my pet on a leash. This is private property. Our policies, you signed it in the pet addenda and or in your lease as part of your lease, that we require leashing, not control on our property when you're on or near the property. And then I would say require at a minimum that all pets be up to date on their rabies vaccination at a minimum, and consider requiring spay or neutering while allowing exceptions for both if the pets are below a recommended age, right? So if a pet is, below the age of 2 or 3, you can do the reading on this with the veterinarians and see what the common conversation is. But there is some discussion about spay or neutering being done too early can be harmful to a pet's health. But the statistic that I read, and I think this was the Virginia Department of Health and Environmental Control, said pets are not spayed or neutered are 3 times more likely to bite. So that's important to note. So those would be my suggestions for strategies, for protecting both people and the pets, right? Because pet aggression on other pets is certainly an issue as well. And our renters, 97% of those who own pets in this country consider them family. So these are their furry family members. And so you want to protect the people in your property, the pets in your property, and your property from, risk as well, and liability along with it. Amanda, did I miss anything there?
No, I was just going to add a couple things. I think you covered everything very thoroughly. I think, the biggest takeaway from that, from what you said, I think is the fact that, the knew or should have known part. There is so rarely in any liability case, somebody knew something. I mean, we just never are dealing with this person knew there was a dangerous condition and did nothing about it. That's very rare, especially with multifamily housing properties. So the should have known is always where these cases hinge on, and where they tend to linger, and everyone's arguing for so long about who should have known what and when. So that standardized questionnaire, whether it's a separate questionnaire, whether it's specific questions or admissions or authorizations or whatever you want to call it in your general addendum, having those dog owners sign off that your pet has never been involved in a bite or an incident and doesn't have dangerous propensities. If you are getting that representation from them and have no reason to believe otherwise, that's a very strong defense. It's not a blanket defense. You can't have them sign that and then you see them attacking somebody on the property and you're like, well, they said they've never bit anyone before. So you have to make sure that you're staying on top of what you do know and what you're observing as you're moving about the property over time. But that questionnaire and that representation from the renters is very significant in documenting your file to, defend against later incidents when they do come up. Having the policies in place, very important. I will say with any general liability matter, whether it's a dog bite or whatever the case is, the worst thing that you can have, the worst case you can have is when you violate your own policies. Regardless of what type of case it is, if I see that my client has violated its own policy, I'm going to tell them right out of the gate, this is not going to end well. No matter what else we have going for us, it's not going to end well. The worst thing you can do is walk into a courtroom, plaster a policy on the screen, and just establish that that was violated. That's like the death nail of any liability case. So have the policies, but follow the policies and make sure that you're documenting as you're going how those policies are being followed. If something is required to be in the file, make sure it's in the file. Again, that's just so important. And then as far as the records, I will just add that it's also important to have those records from the vet as far as a rabies vaccination or updated shot records, whatever the case is, for a couple of reasons. First, typically the vet is going to put the type of animal on the vet record, right? So again, that helps with that breed issue when we're not talking about the ESAs, but a standard pet issue. If someone says I was bit by a pit bull or a mixed breed on your property and they're not supposed to be there, and I had this exact case come up. This is not a hypothetical. The vet records said lab mix. So the property has the records on file. This dog is a lab mix. And the plaintiff, of course, and her attorney are saying it's a pit bull. And we have this giant issue of what kind of dog was it? Well, the vet, who's the specially trained professional, if they're saying it's a lab mix, we're going to probably defer to them, right? But that's why having those vet records on hand can really be helpful. Also, it's also helpful to have those on hand in case someone is bitten on the property and the dog owner might not want to cooperate right away, or they might be trying to cover things up or not want to deal with it. The property can provide that rabies vaccination to the person bitten because they're going to want that information as soon as possible to confirm that the dog is up to date on its vaccines.
And you brought up dog breeds slash mixes. What are some of the legal limitations on restricting certain dog breeds or sizes, even under fair housing laws?
Typically, as long as it's not an ESA restriction, properties are generally fair or able to restrict certain breeds, certain size limitations. I think it's reasonable for properties, and especially in a multifamily housing property. If there's we're talking about apartments here, I think it's reasonable to restrict size and breed, and it's private property. As long as you're not violating these fair housing laws, you can go ahead and do that. But that's again where you have to be very careful about if it's an ESA, then you have to allow that animal as long as the documentation is proper. So breed restrictions are not uncommon. A lot of properties I've seen in their training materials will put, your typical, your pit bull, maybe your chow. And, everyone's going to say that I have a pit, everyone's going to have a dog or an experience that doesn't fall within that. And that's totally understandable. And unfortunately, some of these breeds just have bad reputations. At the same time, the properties have to prevent against potential risk. And if the statistics support that, then they're certainly entitled to do what they need to do for their property, with the exception of the ESAs.
And continuing the conversation surrounding safety and strategies to keep the property safe, the residents safe. Victoria, I wanted to ask, what's the best way to handle if two separate residents have dogs that just don't get along?
Yeah, that's a tough one. A great question, Jen. There's 90 million plus dogs in the US. You can easily have dogs that don't get along. And of course, they're trying to decide who's in charge, right? Triple I insurance website said there were 22,000 plus dog bite claims last year. And gosh, those claim dollars in California were over $208 million one year. So I say that to say there's a great risk to the people and the property and the finances where aggressive dogs are concerned, even if it's dog on dog aggression, because oftentimes these bites will happen when there's a dog on dog aggression, and then their humans reach in to try to resolve the issue or separate the issue, and then that's when they get bit. So starting with those facts and moving forward, if there's a dog on dog conflict, that's your trajectory starts there, of course. So as a former operator, I'd say depending upon the level of aggression or situation, first, are either of the dogs having a problem with any other dogs or just each other? If it's just each other, that's easy. Hey guys, you got to keep them apart. And how to navigate that and just having those conversations with them. Because if we're just talking about pets, we're not talking about anything that's protected, right? If you end up with a dog or an assistance animal, more importantly, more difficulty there, that's demonstrating aggression. When I've talked with attorneys around the country and some of our clients, and you're talking an assistance animal and you're trying to respond to somebody's assistance animal being in the community and having some aggression, it's been suggested a couple of times now that a good first stop is going to be negotiating the conversation with that assistance animal owner that they're willing to muzzle. We had a muzzle on that cute dog earlier, that they're willing to muzzle that animal when on or near, and then being very clear about what is near the community as well. Because one of the discussions I had with a large REIT, with the leading attorney of a large REIT, there was a dog park like right outside the gates of the property. And so they realized that that should have been more carefully stipulated. So one and done, you can certainly have a situation where there's one and done if there's bites and problems, because you get into the what did you know or should you have known. But if you're dealing with an assistance animal, sometimes if it's not too great of an issue, that nothing harmful has yet occurred, then you can kind of navigate that conversation and maybe approach it from the muzzle conversation. But again, you've always got to be careful before you get to that line of crossing that line of what you knew or should have known and what did you do about it, because those are always the questions that the litigants are going to ask you when you're on the stand. I've had that experience. So that would be my suggestion. If it's just two animals that are just not getting along, but they're okay with everybody else, just keep them apart and talk to them both about that, because you're going to let them know as an operator. It's hard to say when these two don't get along whose fault this is, and I don't want to ask both pets to have to leave. So you guys need to really communicate and make sure you're not in the bark park together, and that if you see each other come in, that you wave off in the other direction, right? Just being good neighbors and good for the community. But if it escalates from there, start negotiating specific solutions or removal.
And one more question before we continue on. Victoria, how, especially having been a former operator, how can a community successfully enforce leash rules, breed restrictions, and also barking complaints?
So, like any other rule in property management, that's a great question, Jen. Thank you for it. It has the impact of the consistent force placed behind it. And like you heard Amanda say earlier, don't have a policy that you're not willing to put that consistent force behind. Because if you turn a blind eye, it's what you knew. It becomes what you knew. It won't be a blind eye very quickly to be documented that you knew or that you should have known because it happens so prevalently. You're negligent that you don't know, right? And so you're dealing with these from that perspective. But again, every rule we have has the force of the consistent force behind it or has the impact of that consistent force behind it. So if you have a leash requirement but don't enforce it as a tool, then the policy becomes less than helpful and it can actually harm you because you have that policy and you're not following it. So the overarching answer here would be through communication, communicating the rules, not just at move-in, but through other events, communication channels, and strategies. For breed restrictions, of course, inquire about the breeds at the submission of the pet information. Here at Pet Screening, when our end users complete a pet profile, they can't just say mixed breed. They have to select the two breeds, the animal that they're willing to stipulate the animal's most comprised of. So they can't just say lab mix or schnauzer mix. They have to say schnauzer shepherd. They have to pick two breeds, right? So having them answer those questions and drawing them and their answers on the record into the conversation is really important. So also, I would say requiring photos, potentially consider reviewing those at submission, requiring at least a rabies vaccination, and potentially even that documentation, because as Amanda pointed out earlier, that documentation from a veterinarian will always say what type of animal it is, like lab mix, and it'll also have the weight on there as well. So I have found that to be really helpful. But at the end, you've got to get this information from the pet parents so that you're relying on what they're saying. But again, you're also relying on your eyes. So if they say it's a Chihuahua mix and in walks a Rottweiler, right? And I use that for hyperbole on purpose. We do still have to rely on our own eyes.
Okay, thank you for that, Victoria. All right, so here we have just a really quick video that kind of highlights how Cloudastructure and video surveillance. As I mentioned earlier, as a former property manager, I worked on properties that did not have video surveillance. And so it was always my word against the residents, which could sometimes lead to confrontation, unhappy residents. So that's one of the biggest factors that when I share some of the features of Cloudastructure with the customers that I'm showing it to, that's their favorite features, the searchability. So if I had Cloudastructure on my property once or twice a week, I would have one of my leasing agents go on. You can literally type in the word dog and it'll narrow down the amount of footage that you have to look through to any instance where there's a dog present. And the ability to share that footage with your resident is as easy as the click of a button. You type in their email and you can say, hey, you owe us $50 for not cleaning up after your pet. Or, hey, you claimed you didn't have a pet. We need to get the proper documentation for you, Amanda, collect the pet deposits, the pet fees. So it could be a way to really protect yourself and protect yourself from the liability that is present by being a property manager, property owner. And so having that surveillance surrounding your dog parks to protect from if a dog bite does happen, there's surveillance that can be present, that can be utilized in court that will, again, protect yourself from that potential liability. So a lot of ways that Cloudastructure and surveillance can be utilized to kind of help mitigate some of these liability issues that are present by being a property manager or property owner. And then there's also a follow-up question on if you would like to automatically be added into our next webinar, which I'll kind of go over here in a moment. That being said, we're going to go ahead and jump into the Q&A. If you haven't already, go ahead and throw some of your questions in there. So Adrian, should a generalized animal policy be included in subdivision, single-family homes, HOA's policies to avoid animals wandering off property, pet waste, cleanup recommendations? Amanda, do you have any insight on that?
I think generally, yes. I don't think there's ever a bad time to have a policy. Again, follow it if you have it. That's my only recommendation. But I do think that anytime you have an HOA, because again, if there ever is an incident in a common area within the subdivision on a walking trail or near a playground or whatever the case is, the HOA could potentially be a party in a lawsuit even if they had nothing to do with the situation. So yes, I mean, again, the more policies you have, as long as they're being followed and people are aware of them, I don't think it's ever a bad thing to have policies as long as it's reasonable to enforce them.
And while we're waiting for any other questions to pop up, if you have any other questions, I know we're nearing the end here. Go ahead and throw them into the Q&A or the chat. But it looks like Danny Lee McCarthy, your pet won the cutest pet contest. And so you will be getting some information surrounding your winnings, which is a gift card to Crown and Paw. So you'll be getting some pet portraits for your adorable dog. Congratulations, Danny.
I saw a couple of questions in chat that we could hit really quickly for your audience. So somebody mentioned in Q&A, you said new update from HUD. When was that? So I'll share that is the 2020-01 HUD Assistance Animals Notice. That was the first communication we've had from HUD in 7 years, because the one before that was from 2013. Please also Google joint DOJ HUD letter on this particular topic of assistance animals, and know that the original legislation contains points and requirements for us in our industry that you're not reminded of in that joint letter, and that you're not reminded of in the most recent HUD notice either. So I just wanted to hit that for you. That is the 2020-01 Assistance Animals Notice from HUD. And then there was one other in here. Can we please be provided the specific questions we can ask? For service animals, the questions are, is the animal necessary for a person with a disability? And what work or task has the animal been trained to perform? And on the support side, is the animal necessary for you? We're going to confirm you're disabled visually or in documentation. And we need to know that there is a nexus, a connection between the disability and the request, that this disabled individual will have one or more of the symptoms associated with their disability ameliorated by the presence of that assistance animal, that support animal on the support animal side. So that's what you're looking for on either side.
Thank you for touching on those, Victoria. And it looks like these might be our last couple of questions, but this will be for you, Amanda. Are surveillance cameras or other monitoring tools legally defensible if used to document pet-related policy violations?
Yes, I mean, typically surveillance footage is used often and is legally available evidence in a claim in court as long as it's properly stored and handled. Obviously, we don't want any questionable footage or stuff like that. That's why Cloudastructure, you'll not have that problem because they do all that for you and they're going to have the chain of custody and all those issues handled for you. But with surveillance footage, as long as the cameras are working, you have the footage and the chain of custody issues are not in question, yes, then you can use surveillance footage to defend against pretty much anything in court, unless there's obviously other evidentiary issues, but that's not going to be an issue.
And Victoria, this last question will be for you. What's a good rule of thumb for running out of patience with a problematic dog, i.e., how many offenses? And also, have you seen any anti-aggression policies, and how would that work?
So those are great questions, and it's really going to rely on, and Amanda is going to shake her head on this, is what are you running out of patience with? Is it anything that demonstrates to you that there is a hazard in your community? There you're not dealing with patience, you're entering negligence, right? Because if you have any knowledge that the dog has aggression towards people and is difficult to handle, then you're potentially getting into a negligence area. So maybe one of those, and I would be sitting down to have a conversation about muzzling, and then if that muzzling agreement it's not followed or there's any issue after that, then it's gone. It depends upon too, are you in a strict liability state, a one bite state potentially, or are you in a negligence state? But really, I think regardless of what the law, the overarching law is in your state, it depends upon your patience level, depends upon the problem. Is it barking or is it aggression? Is it being a poopatrator? Right? What is it that you've had patience with? And is it patience, or are we getting into a point of negligence? So you've really got to guide yourself from that perspective.
And last question here, and then we'll kind of go over some contact information. But Alan asked, can surveillance footage include voice? So a lot of that comes down to some specific state laws. two-way recording is not always legal. So we err on the side of not doing voice on our surveillance, but it is an option if needed. That being said, like I mentioned earlier, we do have the speaker portion where our guards can talk down over the speaker and deter any unwanted activity. So that being said, thank you all so much for your questions. I'm going to go ahead and switch the slide. We've got some contact information for each of us, for myself, Victoria, and Amanda, and we're all open. If you guys have any questions, please do not hesitate to reach out at all. And then we have our next webinar coming up July 31st in just a couple of weeks. It'll be a resident altercations and landlord liability, what every multifamily owner needs to know. So another good one coming up here shortly. And again, thank you so much to Victoria and Amanda for joining us on this webinar. Your expertise and knowledge is super appreciated. I really was very happy to have you guys on this panel. Thank you all for joining. I hope you have the great rest of your day. And again, don't hesitate to reach out if you need.